The Beyond Holistic Advocacy for Movement Lawyers will be our last session today. I know that most of our attendees are lawyers, and probably the first thing you think about when I mention the word advocacy is impact or strategic litigation. As Professor Larissa Brent mentioned this morning, that's because we are trained as lawyers to have a rather narrow view of what advocacy is. In Australia, the vast majority of community and social justice law revolves around direct service provision and traditional models of impact litigation that often involve lawyers working directly with one client and really at arm's length from impacted communities. In contrast, movement lawyers seek to build the power of communities and movements by utilising a variety of advocacy strategies that include not only litigation, but also strategic use of the media, political lobbying, and awareness raising. This recognises that often changing the law is only as good as the next legal challenge or lawmaker. As Vince Warren said this morning, the law does not change hearts and minds, and to create real systemic change, you often need to change the hearts and minds of the masses. Most of us do not learn these skills in law school, and that is why this panel will discuss the importance of a comprehensive advocacy strategy beyond simply litigation, in advancing movements as well as some of the tools and tactics that are critical to a successful campaign for systemic change, and importantly, why these strategies should be led by the communities most impacted. This afternoon, we are lucky to be joined by three esteemed panelists who have all engaged in advocacy from very different backgrounds, including as activists and members of the media, highlighting the fact that you don't need a law degree to engage in advocacy. First, I'm joined by Rodney Croome, an LGBTQAI+ advocate who has been involved in a number of successful campaigns to advance the rights of LGBTQIA+ people in Australia. He led the successful campaign to decriminalise homosexuality in Tasmania and was also the founder and national director of Australian Marriage Equality. Rodney currently serves as the spokesperson for Just Equal and Equality Tasmania. He has been recognised for his tireless efforts by being named a member of the Order of Australia and was Tasmanian Australian of the Year in 2015. He was also made an Honorary Doctor of Letters from the University of Tasmania. We are also joined by Sophie Mcneil. Sophie is the Australian researcher for Human Rights Watch and was formerly an award-winning investigative reporter. She works with ABC's Four Corners program, where she produced programs on the Hong Kong protest movement and the mass arbitrary detention of Xinjiang Muslims by the Chinese government. She has also worked as a foreign correspondent for the ABC and SBS in the Middle East. Sophie has been recognised for her journalistic efforts and has twice been awarded Australian Young TV Journalist of the Year and has won 3 Walkley Awards for investigations into the killing of children in Afghanistan by Australian Special Force soldiers and for her coverage of Yemen and besieged towns in Syria. Our final speaker, and sorry, Rawan, spoken lawyer on the panel, is Rawan Arraf. Rawan is the founder and executive director of the Australian Centre for International Justice, which is working to develop and promote international justice in Australia by seeking justice for survivors of atrocity crimes by holding their perpetrators to account. Rawan has over a decade of legal experience in refugee protection, administrative law, and international human rights law. She's also actively engaged with lawyers and organisations working on justice for Palestine, global justice, and universal jurisdiction litigation. She's been trained with the European Centre for Constitutional and Human Rights in Berlin and is currently a Fellow of the Centre for Australian Progress. So a truly impressive list of speakers. And I will start the Q&A with our speakers before turning it over to your questions. And if you do have questions for a specific speaker, please just note that in the information you provide in the question. Otherwise, we'll open it up to the whole panel. And feel free to send questions throughout the discussion and we'll get to them at the end, or get to as many of them as we can. So Rodney, I might start with you. As I mentioned, most of our audience are lawyers, And as lawyers, we often look at campaigns for social change strictly through a legal advocacy lens. But there's obviously a lot more to an effective advocacy strategy. Based on your years of experience as an LGBTIQA+ activist, what are some of the most important components of a broader change strategy outside of legal strategy?
As you said at the beginning of your presentation, law reform isn't always our goal in and of itself, and that's certainly the case for me. I've been involved in many law reform and policy reform campaigns over the years, but for me the ultimate goal is to reduce prejudice against LGBTIQ+ people and to promote equality and inclusion at a cultural and social level. And law reform is a part of that because we need to remove those laws that prejudice can find a hiding place behind, and we need to put in place laws that are going to foster a greater acceptance of LGBTIQ+ people. So given that that is my objective and the objective of the people I work with, we do take a much broader approach to law reform than simply changing the law or simply asking politicians to do that, although that's an important element, obviously, lobbying. Probably the most important element that I emphasise is that law reform campaigns, again, the ones I've been involved in, need to be based on and led by the communities that they're most directly affected. And that meant that can often be said as a kind of cliche. Oh, of course, it should be community based. But that means having a perspective on change that always puts community people first, always seeks to empower those who are affected to be their own advocates and to lobby, to advocate publicly, and to determine the direction of the campaign, including the legal strategy. So obviously, professional lawyers are important to involve in legal strategy, but it always needs to be based on what the community wants. And the expertise of community members in understanding what is required to make change, as well as what change is required, underestimating that is dangerous. I found that in all of the campaigns I've been involved in, those people who are most affected know what it is necessary to get where they want to go. The second point, I guess, is, again, because of the focus on community attitudes, public education, working with the media really closely. That's been something that's been a constant in my career over the last 30 years. And another constant has been always foregrounding personal stories. No matter what the issue is, there are personal stories which are compelling, stories of injustice and inequality, which need to be in front of the public almost all the time. At the moment, I'm involved in trying to achieve legislation in Tasmania to prevent conversion practices against LGBTIQA+ people. And that a lot of my time is spent talking to survivors of conversion practices about their experiences, helping them tell their stories in a way that's most compelling, and getting them into the media and supporting them through that. It's time consuming, it's difficult, but it's the only way forward. The last couple of points I want to make, firstly, allies. It's always vital to reach out to other people who share your concerns and who may be affected by the law reform that you're advocating for in ways that you may not have realised to start with. An obvious example here is the religious discrimination bill at a federal level, which takes away or erodes existing discrimination protections for LGBTIQ+ people, but also for others, including people with disability, women accessing healthcare, minority faiths, and a lot of my time is spent reaching out to them and working with them to make the case that it's not just God versus the gays, it's an issue that affects a lot of people who traditionally fall foul of religious prejudice. The final point I'll make, it's always really important for any successful campaign for there to be a sense of place. Although human rights are universal and legal principles apply across the country, every campaign arises out of a particular place and time, and it's important to be faithful to that place and time. When the issue of decriminalising homosexuality was a big one and a divisive one in the 90s, decriminalising homosexuality in Tasmania, because Tasmania was the last state to do that, and it was a very acrimonious issue. We could have talked about the right to privacy or the right to equality, or we could have talked about certain, division of church and state or whatever. But we didn't. We spoke mostly about our lives as Tasmanians and how the law affected us, and how the laws were damaging not only our lives but the life of our island. I found in every law reform I've been involved with since then, a sense of place is really important. That is what captures people's imaginations. There's a lot of other things I could add, but they're the main points that come to mind. And I'll pass on to the next speaker.
Thank you so much. And I think some of the points you've touched on are themes that we've kind of seen throughout the conference, particularly about making sure that advocacy is really led by the communities most impacted. You did touch on using media strategies. And Sophie, as a former journalist, now human rights advocate, I wanted to ask you, how does an effective media strategy fit into a broader campaign for change, and how can lawyers and communities engage with media alongside other advocacy strategies? And if you could tell us or give us examples of what you've seen done well and maybe what you've seen done badly, that would be really helpful.
Thanks, Susie. I'd just like to acknowledge I'm joining you from the land of the Whadjuk people of the Noongar Nation, and I acknowledge their elders past, present and future, and that sovereignty has never been ceded. I think what I've realised since leaving journalism is just how critical advocates are. People like Rawan and Rodney, that's who I'm learning from at the moment in my new role, jumping the fence from journalism to advocacy, because I think, like too many reporters, I just put too much emphasis on just getting the story out there and then just, not what happens next. And I think one of the problems these days is that there's this level of impunity now that means that just because people are aware that something is wrong and that it needs to change, it doesn't automatically mean that the government will be shamed into acting. So that's why I made that jump, because storytelling wasn't enough. And what I've learned is how it's that sweet spot of trying to combine the two, of the advocacy with that storytelling and that media strategy. So I think also, my organisation, Human Rights Watch, we don't engage in strategic litigation. That can have its limitations. And so for me, in my work, it's about building broader movements to really achieve that political support for policy change or law reform. In terms of examples of what I've seen done really well in terms of a media strategy and advocacy, I think the Raise the Age campaign in Australia, I've learned a lot of lessons watching them, being new in the advocacy space, the work of groups like Change the Record, NATSL's, the Human Rights Law Centre, Amnesty, VALS, the ALS in WA, New South Wales, the work, the advocacy they've been doing with a really effective targeted media campaign, including the brilliant documentary In My Blood It Runs, that's really placed an issue right up there on the national agenda, that wasn't a few years ago. So we saw the proof of that when Australia had to appear at its 5-yearly review on human rights in Geneva in January, and we saw more than 30 countries highlight how the age of criminal responsibility was a serious human rights issue that tarnished Australia's global standing. So I'm learning a lot from the work of those groups, and I think that's really effective. I think the 4 corners that they did on nursing homes in Australia, that was an incredible kind of culmination of advocacy of hardworking older rights advocates across Australia who'd been collecting that evidence, lawyers who got together with Four Corners and Anne and again, put an issue on the national agenda in a way that hadn't been before, and contributed to some, quite incredible new funding and protections for older Australians across the country. What hasn't worked? I think It's interesting to look back at the blood, sweat and tears that so many lawyers, advocates and journalists and former detainees have put into trying to hold our government to account for their horrendous, cruel policies on asylum seekers. You know, those wins have been slow and tiny and so much cost, you know, to thousands of people's lives. And I don't think, unfortunately, that those hardworking people could have done anything differently. I think it's an incredibly depressing reality check on how hard it can be in this country to build strong political movements that advocate for the rights of people who are not white. You know, I think that is something we have to deal with in Australia and acknowledge, you know, particularly when someone's continuously painted by some sectors of politics and the media as the other. You know, there wasn't a story that wasn't told about the horror of that policy, but it still didn't develop that political movement, and that continues today. We just saw a new deal signed with Nauru actually this morning. And I think a good lesson that a successful media strategy is not the be-all and end-all is the four corners into the Dondale Detention Centre, Australia's Shame it was called. On paper, that was one of the most successful four corners ever. You know, after it was broadcast, the federal government announced a royal commission into youth detention in the NT. In the month after it was broadcast, there was 23,000 media reports that discussed the treatment of children at Dondale. You know, the UN High Commissioner commented on it. Incredible. But, you know, look at where we are today on that issue. We've gone from, you know, a Labor government in the NT now having expanded Dondale. So not only did they not listen to that recommendation to close it, it's been expanded. They've passed harmful new punitive bail laws that advocates in the NT, you know, tell us have already led to an increase in the number of young people in detention, majority of them First Nations young people. So again, that's an incredibly depressing reality check on how hard it can be in this country to build strong political support for the rights of people who aren't white. And, you know, another failure that haunts me is Syria. You know, there isn't anything that the people of Syria didn't tell you or show you about what was being done to them that journalists didn't report. But, you know, we just failed to capture the hearts and the minds of the policymakers for the steps to be taken to improve that situation for the people of Syria. And I still remember at the time looking back at Sydney from Jerusalem and seeing more people on the streets protesting that the time bars closed in Sydney than they did the starvation that was happening in Ghouta or Aleppo at the time in Madaya. So yeah, a few perhaps lessons that I'm learning and have learnt on the way, Susie.
No, thank you so much. I mean, it's great to know, I guess, the various limitations of various advocacy strategies. So obviously, we've briefly touched on some of the limitations of legal advocacy strategies, but it's great to know that, you know, obviously a media strategy also has its limitations, and that's why we really need to think about a comprehensive strategy. Rawan, maybe you could tell us about some of the legal and non-legal advocacy strategies you use in your work at ACIJ, particularly around universal jurisdiction practice. How do you think about challenging political will and public opinion around a principle not yet widely accepted in Australia? And maybe the non-lawyers in our audience, you could also just briefly explain what the principle of universal jurisdiction is.
Thanks so much, Susie. First of all, I want to foreground my remarks by acknowledging that much of the knowledge in this space is the intellectual and emotional labour of First Nations activists and elders and family members who have fought for decades for truth, justice and accountability. And I want to acknowledge the incredible work of First Nations families and communities in seeking justice for those that are killed in custody across this continent. Just yesterday, we saw Larissa mention at the Advocacy success that after a 5-year battle, a legislative ban on the use of spithoods, which took the life of Wayne Fella Morrison. And I think Latoya is here watching today, so shout out to her. You know, what we're trying to do, it's a huge challenge, and it can't be said that there's any acceptance of the idea, but it's one of our missions, and we're certainly pushing. Universal jurisdiction in Australia is a great example of having a legal framework. You know, the law is available, but there's no institutional capacity, resources or skills or political will to implement it in practice. And I would add, importantly, there's no civil society push, which is, I think, where we come in and what we're trying to do. And the absence of the practice to date, bar a few ad hoc attempts in the past, represented a lack of vision and a failure to understand how universal jurisdiction works, because I think those actions were not connected to a broader global justice movement, and those lawyers who brought it didn't understand what was lacking in Australia, and didn't want to work, I guess, on the advocacy to push for it. So we recognise that and have a broad legal advocacy agenda to make it a possibility and to transform the way that survivors of international crimes can access redress, justice and accountability in Australia. And universal jurisdiction, that is the idea that perpetrators of international crimes, those crimes are aggression, war crimes, genocide, and crimes against humanity, can be the subject of criminal investigations and prosecutions by states, regardless of any links or ties to the state. So regardless of the nationality of the perpetrator, of the victim, and the territory on which the crime took place. And that's because the international community considers that these crimes are so heinous that all countries have a duty to hold those to account who can perpetrate them. Who do perpetrate them. And some examples of UJ include the arrest of Augusto Pinochet in London through proceedings that originated in Spain. In Sweden at the moment, the prosecution of a former Iranian official alleged to be involved in mass execution of about 5,000 prisoners in Iran in 1988. In Germany, currently trials of former Syrian high-ranking officials in the Assad regime's secret service that are being prosecuted on charges of crimes against humanity, including torture and sexual violence. In Germany, there's been attempts to prosecute those involved in the CIA's torture program. In Europe and Latin America, attempts to prosecute Sri Lankan generals involved in war crimes and crimes against humanity against Tamil people. In the UK and Europe, previous attempts at trying to prosecute Israeli generals and defense ministers for war crimes in Palestine. And all of these examples are the result of survivor communities working in partnership with radical lawyers to agitate and push for accountability. So in Australia, we have the law in our legal books, the codification of these crimes, but we've never used them in an effective way. And that's why our agenda includes legal and policy advocacy for necessary structural reform and change, using tools that are tried and tested and used by public interest lawyers, activists and campaigners daily through any available forum, whether that's at the parliamentary level, governmental level, institutional level. And so our theory of change consists of working with affected communities, partners, other NGOs in the global justice movement through legal actions, bringing referrals to trigger authorities to act, and doing it in conjunction with a broader advocacy agenda, but also a storytelling strategy, hopefully, to communicate and gain the support of the broader public on the importance of truth, justice and accountability, and our wider community's role in contributing to peace and justice processes to communities that are impacted by atrocities. And I just want to make one final point about storytelling and public opinion. And the battle for public opinion is important, one, for the idea of UJ to gain acceptance, because changing hearts and minds is a fundamental part of progressive movement building. And you need to be able to translate your victories and failures to shift narratives and change and establish norms. So take, for example, the following statement from a Syrian survivor of torture remarking on his ability to provide testimony to prosecutors in Germany. He says, "This process in Germany gives hope. Even if everything takes a long time and nothing happens tomorrow, or even the day after tomorrow. The fact that it continues at all gives us survivors hope for justice, and I'm ready to testify." So we hope that these kinds of success stories can help turn the tide of public opinion and political will. The concept of UJ to some people, and even to those UJ skeptics, can seem quite abstract, but when people, I think, hear, for example, what it means personally for Syrian or a Tamil torture survivor or an Afghan victim, for example, to be finally able to talk about their experiences to prosecutors and later hopefully in court, they can get a better understanding of the positive and powerful force that such proceedings can be for everyone.
Thank you so much. And absolutely, I think we've talked about actually hearing, not just listening, but actually hearing what impacted communities have to say and survivors have to say. So I think it is really important for those who have faced torture to be able to share their stories and know that they're actually being heard. So I guess I wanted to talk about the theme for this conference, which is shifting power. And I know all of you have kind of touched on this a little bit. in your answers previously, but I wanted to, I guess, dive a little bit deeper on how lawyers can actually help to build the power of social movements, and perhaps touch on how lawyers have also potentially hindered them as well. So Rodney, I might go back to you. As an activist, you've worked alongside lawyers in a lot of the campaigns you've been part of. Would you be able to share with us some of the pitfalls and benefits of working with lawyers, and what role, in your opinion, lawyers should have in supporting communities seeking change?
In a lot of the law reform campaigns I've been involved in, the role of lawyers hasn't only been in regards to, advising on the final law reform. It's also been about helping work on the campaign-related legislative activism or court appeals that get us to that final point. So there's the final law reform, but there's also matters to do with the law that are part of the campaign to get to that law reform. So, like I said, a court appeal, or what I call legislative activism, which means introducing like legislation or legislation in a different forum or a different parliament or whatever it might be. And I'll explain a bit about that. I'll give illustrations of that again in a minute. But the lawyers that I find it easiest to work with are those whose minds are lithe, those who understand the role of the law as a means as well as an end, those who see it as a tool for change as well as the object of change, and of course, as I said earlier, see the law reform itself as only part of an even bigger change, which is the cultural and social change that we've been talking about. I guess what I'm saying is I find it easier to work with lawyers who see what's possible rather than what's impossible. In the 90s, I mentioned before the campaign to decriminalise homosexuality in Tasmania, and our state parliament was very resistant. So, of course, we took advantage of the fact that Australia signed the first optional protocol to the International Covenant on Civil and Political Rights in 1990, or acceded to that protocol, to take a case about the Tasmanian laws to the Human Rights Committee, the first case from Australia. And at the time, when we announced that we were going to do that, that elicited from Michael Kirby, who was then the president of the Court of Appeal in New South Wales, a very great scepticism. He called me and said, and I'm sure he's happy for me to say this because he said it himself many times. He called me and he said, "I don't think this is going to work," in his lovely radio voice, because the UN makes decisions for the whole world and there were so many countries that continued to criminalise male homosexuality. But I had a different view. We'd looked at the precedents that the UN might consider from the European Court of Human Rights in regards to similar laws in Northern Ireland and Ireland, the Republic of Ireland, and in Cyprus. And we thought we had a strong case. So we said, "Sorry, Michael, understand you're sceptical, but we're going to do it anyway." And on that case, which proved in the end to be successful, of course, with the Human Rights Committee condemning the Tasmanian law, on that case, I found it useful to work with lawyers who could see that there was a chance and wanted to maximise that. They wanted to help us find ways to convince the Human Rights Committee that this law had to go. Whereas Michael Kirby had said we hadn't been arrested, therefore we wouldn't have standing. These other lawyers that we worked with said, well, let's find other ways that we can illustrate how the law affects you directly without having actually been arrested under them. And it was a bit the same with marriage equality. So Australian marriage equality started in 2004 with John Howard passed legislation to explicitly ban same-sex marriages in the Marriage Act. And the federal parliament was a long way off accepting that reform. It had just passed, this legislation saying it wouldn't recognise same-gender marriages we could see it'd be many years before the federal parliament would change. So we decided to go to the state parliaments, exploiting that loophole, if you like, in the constitution that says, effectively, if the Commonwealth doesn't legislate for a certain kind of marriage, the states can, which was an argument that was made by George Williams and was resisted by many people at the time. Mostly lawyers, mostly constitutional lawyers, who said, that's ridiculous, it'll never happen. Forget it. But together with George and others who could see the possibility, we expanded that idea more and more until 8 years later, 9 years later, first the Tasmanian Parliament and then the ACT Legislative Assembly debated and in the ACT's case passed a state or territory same-sex marriage law. Now that was struck down by the High Court, but it meant that for a week in the ACT, there were same-gender couples marrying and the sky didn't fall in. That was a really important step forward. Plus, the High Court, even though it struck down the ACT law, said that the Commonwealth had the constitutional power to enact marriage equality, which wasn't clear until then. So I'm citing these because I just want to illustrate the importance of working with lawyers who can see the possibilities and are working to open up those possibilities, rather than just shut things down and say, no, that can't happen. That's never happened before, so it won't happen now. The final 2 points I'll make are, it's really important for us, for me and the people I work with, to work with lawyers who are going to give their advice, but understand if we don't take it or if we follow a different direction, who won't try and direct us. Because again, it's about the people who are most affected. I also like to work with lawyers who aren't going to portray the people affected as victims, because that doesn't help anyone, who are there to empower us, not to sort of just put us on the stand and say, oh, look at this poor person oppressed over here. And also lawyers who can translate the jargon they learnt at law school into English so that people can understand what the basic concepts are. The concepts of the law aren't difficult, and not at all. It's all fairly straightforward. It just needs to be expressed for community activists in a way that, or in plain English, so that we can then communicate it to the public so they can understand what it is that we're on about.
Yeah, I think as lawyers, after going to law school, I think we're very good at just keeping the law to ourselves and not sharing it with those that aren't our direct clients. And from the examples you've given, we're also very good at saying no. Rawan, how do you think we as lawyers can critically think about how we engage with communities? I mean, Rodney provided some great examples of how lawyers have tried to limit radical options, but how do you think we can ensure that we don't limit the radical options that those we represent want to pursue?
Yeah, I think there's a tension inevitably, and between direct representation of vulnerable people and being at arm's length to communities, which I think those really great questions that were answered really well by Vince Warren this morning. But one of the examples I wanted to raise, at least from what I've seen, not being directly involved, but just being involved in terms of advocacy around Afghanistan. So a really great example, I think, is that can be seen, that can be shown how it can be done, is the emergence of the Afghan Australia Advocacy Network and its important connections with refugee and community legal centres, who are providing resources and support. But importantly, the Afghan Australian Advocacy Network is leading the way on key demands on the Australian government. And so this advocacy obviously is ongoing because there's so much work remaining. But it's already had a huge impact in galvanising public opinion, so much so that the government has set up an advisory panel of mostly Afghan Australians as a response to the pressure. But I think the key takeaway here is the evidence of how lawyers and legal centres can provide support to communities by amplifying messaging campaigns and sharing resources to maximise the impacts of the demands of the network and the Afghan Australian community to reach the broader public. And so I think this is a good example of shifting and building power to people directly affected and working together and sharing resources and power to lift up communities. One bad example I want to share is an example of how lawyers can ignore communities and ultimately fail in their aims. And a few weeks ago, I tuned into a seminar involving a few lawyers talking about the prospect of international crimes investigations and prosecutions in Australia, including under the principle of universal jurisdiction or extraterritorial principle. And there were questions about, well, when do you think the Australian Federal Police of the prosecutors will undertake such work? As if authorities will act on their own initiatives. And I think the responses were totally ignorant of the role of survivor communities and radical lawyers in pushing for referrals and compelling authorities to open investigations. And I think lawyers can, in this example, can lack understanding of how communities and people directly affected are really the fundamental part and the key to change. One of the ideas I want to reflect on, and it's the issue of this, how we shouldn't be stopping radical demands, is something that Vince Warren talked about this morning, that I think we should do more as movement lawyers, is to think about the intersections of movements for social change. We work on global issues, and it can be quite frustrating at times to see how insular civil society organizations and lawyers can be to issues around the world where we could at minimum be showing solidarity. And I think as movement lawyers who value structural and systemic change, if we aren't looking at root causes and connecting our local struggles with oppressed peoples around the world, then we aren't really doing our job. So here we see the implementation of settler colonial policies and the devastating impacts on First Nations communities. And I see First Nations communities more than lawyers in the legal centres that they work with that are connecting the dots between their own struggle here and the struggles in Palestine, in West Papua and in Western Sahara and other places. And I think that is effective movement and coalition building that we aren't seeing, and we should be doing more as movement lawyers. Similarly, regarding the intersections of the climate justice movement, earlier this year we collaborated on highlighting the role of Adani Ports as business with a Myanmar military company, working together with Rohingya community here in Australia, covert activists in Myanmar, Justice for Myanmar, and the climate justice and Stop Adani movement. And it was really inspiring to bring together all these groups together who work on different issues but can see the intersecting struggles against a corporate giant, and then thinking of themselves as working on really radical issues that they don't work on their normal everyday issues. And another broader point I just wanted to reflect on when not obstructing radical demands of communities and movements, I think, is that we need to acknowledge the structures that we work in at times can themselves be a problem for progressive social change movements. And when I'm talking about here is that the fact that we work in non-profitization models and who have associated regulations that can really stifle our ability to be involved further in advocacy. Our organizations are non-membership organization models, which have their own limitations and can themselves be inhibitors for change. So I think just recognizing that is also important to reflect on where you can be more helpful and where you can shift power in one way. And I think legal advocacy is really one way in which we can transfer our skills and ally with and build the power of community and social movements.
Thank you so much. And touching on, I guess, allies and coalition building, I know Rodney touched on this as well. And Sophie, I know you said that you've been kind of building coalitions recently. What have you learned about coalition building and seeking out unusual allies through your work?
Thanks, Susie. Yeah, I mean, seeking out unusual allies bit is very new to me, having made this jump from journalism to advocacy, because one thing I never really liked about journalism was that there was no real engagement with the people who you were criticising, the people whose policy you were trying to change or position. Often, sometimes that wasn't possible, but in many cases, it was a very adversarial relationship. You just threw the stones, rather than try and change their opinion, the people who had power. So a real focus of my work at Human Rights Watch is to engage with those people who have the power to try and change their minds. And an example of that strategy is when we put out a report last year about the deaths in custody of people with disabilities in Western Australia. To actually have a meeting with the Commissioner of Corrective Services and to sit there and tell him before the report came out all the things that we were going to say about the failures in his prison system. It was the first time I'd done it, because as a journalist, I just would have, just done an interview and just surprised him with all of the things I'd gathered, but this was about working with them and talking about the recommendations we were making and what actually was practical, rather than just, you know, making policy recommendations that couldn't work in that kind of system. So I think for people who want to engage in this space, that's a really important lesson that I'm learning right now. And what you can find is that a big organisation like Human Rights Watch can get that meeting often, you know, whether it's with the Commissioner of Corrective Services or a minister or whatever. And I acknowledge that smaller NGOs and lawyers in this country might have issues, but, you know, big organisations like ours do partner with groups, because we know the weight that we can bring as a big international organisation, 500 people around the world. So I, you know, really recommend that for people listening who might need help getting access to people that they can't, you know, contact, whether it's us or Amnesty or Greenpeace or, you know, whoever that big player is. You know, I think that's a really important role that we have, is to partner with local NGOs and smaller partners to try and help them get that access, because there's something about sitting down with the people who you've have the evidence of their failures and trying to talk through, you know, the policy solutions. A really interesting example I had recently was a report I did that highlighted failures in the Australian higher education system. We did 50 interviews across 17 universities in 6 states and territories, talking to Chinese students and academics who focused on China. And we really exposed how the Australian university education system had failed to protect these Chinese students coming to study here from the CCP, and how they were vulnerable to harassment and intimidation by Chinese government supporters when they criticised the CCP. So they come all the way from China to study in Australia, but they still feel in many ways like they're living under the Communist Party. You know, that report would have made a great Four Corners. You know, I would have gathered all of that interview and those interviews and the evidence, and you know, no way would I have told the universities what I had. You know, I just would have, like a week before going to air, I just would have sat down a couple of vice chancellors and just, you know, been very adversarial and just would have massively dumped on the universities and their failures. But you know, my approach now as an advocate and working for Human Rights Watch, you know, once these key themes emerged after I did all these 50 interviews, was to reach out to the universities and to sit down with vice chancellors and deputy vice chancellors and let them know what our findings were and what we thought the recommendations would be, and work together with them, because we'd seen in the past how they'd really push back on these claims, you know, that they basically were turning a blind eye to this harassment and intimidation because of, you know, the golden stream of money that comes from full fee paying students from China. And so we thought that if that approach would be best to bring them on board and try and get them to adopt our policies to protect vulnerable students and staff from this harassment and intimidation. And, you know, it was really quite successful. You know, with the evidence that we gathered and how we presented it and how we worked with the university sector representatives, as well as specific deputy vice chancellors and vice chancellors who we knew were aware of these issues and we could bring on side. You know, when our report did come out, we didn't have any pushback from the university sector, and we had several universities actually welcome our work, despite the fact it was so critical of them and their failures over the last few years. So I learned a lot through that approach, and yeah, I think that, you know, even working with all sides of politics and with people, you know, won't agree with you, but they might agree with you on one issue. And at least next time when you're trying to get change on the issue they don't agree with, at least you have a contact point. You know, you have someone to go to and just sit in the room. And it's very hard to defend indefensible things when you're sitting in front of someone and you've got all the evidence and facts in front of you too. So yeah, a few lessons that I'm learning, Susie.
No, thank you so much for sharing that. And I think that's right. I mean, once the doors open and you've got a contact, it's a lot easier to try and get straight answers and potentially, you know, change someone's mind on certain positions. So it's great to see all of the new skills that you've learned about actually engaging with these unusual allies. I'm mindful of the time, and I know that we've got some audience questions, so I might just ask one final question, and then if we do have time, I'll come back to the questions I kind of have prepared. But just thinking about the life cycle of an advocacy campaign for change, and I know that a lot of these campaigns can take decades of hard work. how would each of you define success in campaigns for systemic change? Rodney, I might start with you. How did you know when you had achieved it in the campaigns you were involved in, and how do you protect those gains and prevent backsliding?
Consistent with what I said earlier about wanting to change attitudes, if a campaign for law reform results in A, the law reform, and B, a change in attitudes, then it's been a success. And marriage equality is an obvious example. Same-gender relationships are far more accepted in Australia today than they were in 2004 when the Marriage Act was amended to ban the recognition of same-sex marriages. There's still a long way to go, obviously, but there's been a demonstrable change. So I consider that a success. But then to the question of backsliding, there has been, right around the Western world, particularly in the United States and here, a significant backlash to marriage equality. In Australia, it takes three forms. The push for so-called religious freedom, which means rolling back discrimination protections to allow discrimination in the name of freedom, as per the religious discrimination bill I mentioned earlier. It means it's taken the form of a backlash to trans inclusion and equality, particularly in sport and particularly for young trans and gender diverse people. And it's taken the form of backlash to any kind of affirming curricula or support for LGBTIQ kids in schools. And I guess the first thing I'd say in terms of being ready for a backlash and trying to defend the goals the achievements you've had is be prepared to continue to fight on. A lot of people in the LGBTIQ community are really disillusioned that there's been this backlash, and that even though Australians voted yes in 2017 to marriage equality, our rights are still subject to this sort of constant attempt to erode them. And we have to accept that this is a long movement. It's going to take a long time. We may have been up at the top of the wheel, but we've been plunged down into the mud. And the cart is not going to move forward until we continue to push it and the wheel keeps turning. And what do we do to push it back up? Well, the same things we did before. As I said, we need to reach out to allies. We need to highlight the harm that's being perpetrated by those who want so-called religious freedom. We need, and who are attacking trans people relentlessly. We need to make sure that we don't let them entirely frame the debate. So that means not using the term religious freedom, because that's not what it's about. It's actually legal privilege for pretty old-fashioned prejudice. It means that we can't really expect the powerful people who were there in 2017 supporting marriage equality to continue to be there. I'd like them to be, but they're not. We have to do all of this work ourselves, unfortunately, because a lot of the people who jumped on that bandwagon have gone. We need to be prepared to prick bubbles of complacency. A lot of Australians think it's all done because they voted yes in 2017 and aren't aware of the backlash or don't want to pay any attention to it because it's too difficult. We need to, and to do, like I said before, all of the things that we've traditionally done, particularly to tell personal stories about how this new attempt to try and roll back our lives affects us, and continue to educate the public and educate politicians. I'd like to think that that's beginning to work. We're seeing a slight lessening of the anti-trans campaign and a slightly less conviction on behalf of the federal government to roll back discrimination protections in the name of religious freedom. Perhaps it's working. We'll probably won't know until next year, but we just have to keep on going. It means being very persistent, persevering, and realising that just because you've made a gain doesn't mean it's going to stay there.
No, thank you so much for sharing that. I mean, it is very sobering when you kind of, as you said, think you've reached the top and then you're back in the mud. Rawan, Sophie, do you have anything to add in terms of how you would define success in a campaign for systemic change?
Oh, look, I know we don't have too much time, but I just, what Rodney said, I think in terms of really changing attitudes, not just, if the policy changes, but the attitudes haven't, then yes, it's easier to then change the legislation in the future if you haven't created that popular political support for whatever you're trying to achieve. And, when the reality has changed for the people who needed that policy change or that law reform, when their daily reality has improved, that's when you've won. And, that's why I think we'll keep fighting until that happens, because that's what it's all about.
Yeah, echoing those points, I think one thing I just wanted to talk about is, how we deal with setbacks and failures. And I guess just one point that I've learned from, someone called Purvi Shah from the Movement Law Lab is that we have to train and sustain ourselves as lawyers working with communities and progressive movements to think and reflect on our work at all times. And that is how we can reimagine our practice. And the three key questions that we need to keep asking ourselves is, why are we doing what we're doing? Who are we working on behalf of? And how are we working with them? And all of those questions necessarily entail questions about what is success at any point of the campaign that we're working on, and what are the failures and how we can use those failures. And of course, we saw the brilliant example this morning from Vince Warren when he was talking about the Syria lawyer in the South African example, about how the community itself was the one that said, oh, okay, well, this is not, that legal tool that we used was not a success, but we're going to use that to power on our advocacy and to continue the struggle.
Thank you so much. And yeah, that was a fantastic example from Vince Warren. I might move to questions from the audience, and we've got a great one from Professor Larissa Brandt for Rodney. She says she's a long-time admirer of your advocacy. You were particularly successful with your campaigning during the AIDS crisis, where you engaged with a public health response as well. Looking back, what lessons should we take from the success of that advocacy during that period?
I didn't quite catch that. You're talking about the 1990s and the dealing with decriminalizing homosexuality during the AIDS crisis?
Yes, and she said you engaged with public health response as well during that time. Well,
every attack line is also a line that can be turned around. When someone comes racing at you with an attack, like, homosexuality causes AIDS, and so we shouldn't decriminalise it, which was a common point in Australia, not just in Tasmania, but when law reform happened in the other states as well, after 1985, then we can flip that around, judo style. We just have to make sure that we're at just the right point, like someone who's proficient in judo, to be able to take all the energy that all the negative energy that someone's running at you with, and flip it around against them. And obviously, in terms of the public health argument there, the way that's flipped around, the way that it was flipped around quite successfully, was to highlight that, yes, gay men were at greater risk of HIV, and that's why they shouldn't be driven underground by these ridiculous, archaic criminal laws, that we need to reach them, educate them in order to prevent HIV. And Tasmania was actually the first state, as part of this decriminalisation debate, to adopt a HIV/AIDS Preventative Measures Act, which was the first legislation in Australia to recognise same-sex relationships. At the height of the debate about decriminalising homosexuality and HIV prevention. So yes, there's always an opportunity, if someone's running at you with this, what they think is they're going to flatten you with this argument, to at the right moment, use their energy against them and flip it around. And of course, the other way we flipped it around was that we reframed it as a debate about human rights, not just about public health, and we did that by taking the UN case I mentioned before. So after about 1991 or two, the debate in Tasmania really became more about human rights. It wasn't about HIV prevention so much anymore. That debate was flipped around and neutralised, or that attack line. But like I said, well, all of that's important for public debate. What matters more than that is the personal one-to-one connection. And we made an immense effort then, as we did with marriage equality, to make sure that people who supported the reform could advocate for it themselves in a way that drew on their personal story to convince others that it was a reform that mattered. To me, in the end, that's more important than any of those points about public policy. It's a personal connection.
Thank you so much. I'm very mindful of the time. So what I might do is some of the panelists have time. I might post some of these questions so you can answer them potentially in the Slack channels. And mindful that we need to finish on time. So I might hand it over to Brooke to wrap up. And thank you all so much. This panel has been absolutely incredible and just so insightful to learn from your experiences and to know how we as lawyers can be better at helping communities advance their causes and really help movements